this has really been quite the team effort between CSAC, RCRC, and UCC. Of course, we also had significant technical input provided by two county councils in particular, Wylene from Tehama, who is joining us today, and Christina Robb from San Bernardino County. Throughout the year, we also kept in touch with the agricultural commissioners, the environmental health directors, and the health executives. So, before the three organizations got engaged in the legislative process, we thought it was very important to adopt policy principles to guide our work on the legislation. I should note that our position did not involve any sort of taking a stance on being for or against the use of medical marijuana. It was purely about representing county issues in the legislative process, or addressing their concerns with any sort of proposal in the bill package. Generally, all three organizations supported the establishment of a statewide framework regulating medical marijuana, given all of the issues that have risen over the years regarding land use, zoning, the environmental problems, public safety, and law enforcement, to just name a few. Specifically, the key common themes of our policy principles, which are noted here on slide 2, directed us to advocate for the preservation of local control, ensure that counties have explicit taxing authority. We also supported the replacement of the collective model with a strict licensing scheme, and we of course wanted that the environmental impacts to be addressed. Of course, we ended up with this 3-bill package, which included AB 266, SB 643, and AB 243. I won't go deeply into the background, how we got to this point, but I can say that over the last 2 years, we've been working on various different iterations of the proposals. And of course, as noted, it wasn't until the last 10 hours before the end of the legislative session that the 3-bill package actually became public. And I should note that this is not the easiest read by any means. It is an interlocking package, and we would highly recommend that you review it carefully, and you should definitely involve your legal counsel. So I'm going to get a little bit into the provisions of the bill package that address our common principles. So this particular slide 5 just cites the various sections where the local control provisions were included. And I should note that we were encouraged early in the process to go along with just one overarching local control provision. We did not agree with that. We felt it was very important to include local control provisions throughout the package because of the complexity of the various issues addressed, and to ensure that counties can help avoid or at least mitigate any sort of potential litigation. Should note that not every local control provision was included, but we are very happy with what we got. So this is just the citation of those 4 sections. So the first section on slide 6 that's noted specifies that nothing new in the law supersedes or limits existing local authority, and this would cover all local ordinances. Slide 7 cites city and county constitutionally granted authority to establish requirements for regulation of cannabis activities, and also specifies that certain statewide standards are minimums, so locals can adopt stronger requirements if they so choose. And I should say that this particular section and the prior section probably can be relied on to defend a ban if that's the direction you want to go in. Okay, slide 8 emphasizes that the new law or any new regs can't preempt local authority. And slide 9 is a provision from AB 243, which addresses cultivation. It ensures that licensees comply with local rules. And Jolena will be discussing this later on with respect to the exemption for personal grows and caregivers, and she'll also be talking about the infamous March 1st deadline provision related to cultivation ordinances. So slide 10 deals with the taxation provisions. The first bullet provides counties with explicit and broad taxing authority. We felt it was very important to have this spelled out in the bill package because in the event of any sort of litigation. And I should note that while you'll have this authority, you would still be required to comply with the provisions of Proposition 26 and 28, thus giving voters final say on any sort of new taxes that you choose to impose. The other section reference allows counties to impose a tax on each delivery transaction, and the third citation indicates that locals retain existing powers to impose fees and taxes. So slide 11 gets into one of the main purposes of the new laws, the establishment of a strict licensing scheme. While the licensure requirements are spread out through AB 266 and SB 643, this particular provision has the effect of ending the collective model and clearly specifies that a person can't engage in commercial cannabis activity without a state license and local authorization, whether it's via a permit, license, or other sort of authorization. So you can't do one without the other. And then slide 2 actually, I'm sorry, slide 12 actually gets into the environmental aspects of the package. This particular slide focuses on the grants and the funding opportunities, but I just want to mention that the environmental protections are primarily included in SB 643 and AB 243. So while not addressed on the slide, these new environmental requirements impose restrictions on water and chemical use and require the state to take specific actions relative to water diversions and discharges. And these provisions would generally be under the purview of the California Department of Food and Ag, the Department of Fish and Wildlife, and the Water Board. I should also note that the Department of Pesticide Regulation would be responsible for developing standards for pesticides, pesticide use. So actually regarding the slide, it does specify that regarding funding, that it dedicates fine and penalty monies to state and local environmental enforcement efforts. It also would establish a grant fund that would be accessible to locals for environmental regulation and enforcement activities. And regarding the cultivation standards, California Department of Food and Ag would be the state entity responsible for administering the cultivation provisions, including the issuance of licenses, development of regulations and standards, and the establishment of a track and trace program. SB 643 and AB 243 also specify the various cultivation types, categories that could be licensed, such as indoor, outdoor, specialty indoor, and outdoor, etc. So with that, I'm going to turn it over to Jolena.
Hello, I'm here on a fun animation page here on slide 13. We're talking about the licensure exemptions. These are both in AB 243 and SB 643. The bills provide exemptions from licensure for a qualified patient, a primary caregiver who is also allowed to cultivate, transport, possess, manufacture, there's a long laundry list, for no more than 5 patients. The personal grows of 6 plants are allowed for patients under Prop 215. Local control applies to those exempt right now. So this is Section G in AB 243, which provides that even though you have the patients and the personal grows that are exempt from the provisions of the licensing in the bill package, it currently states that local governments can still regulate, ban all of these activities. However, this was a very hard-fought provision in the bills. We fought pretty much all year long on this provision. There are not similar provisions in the other two bills, which previously there had been. So we may see proposals to eliminate this section G, which is problematic, and we do have some concerns with that. So we just want to warn you that this could go away. So if we don't have the ability to take action or regulate these types of activities, even those people for those exempt can continue to do anything, even if you have a ban. The next slide, slide 15, talks about the personal grows that are exempt from state licensure. So even if you have an exemption from state licensure, there are limitations as to how large your personal grow can be. If your personal grow exceeds 100 square feet, as noted in the slide, you have to get CE authorization, which is from CDFA, Department of Food and Agriculture, which will provide the authorization. And a patient caregiver grow exceeding 500 feet must have seed authorization. So there are some limitations on those grows. Dual licensing was a critical piece of the bills, primarily for the cities. The League of California Cities advocated for this for a couple of years. While we weren't super thrilled with the dual licensing idea, I think it does provide some flexibility for local governments. So you have to have both a local license and a state license to operate in the state. So this was critical to provide additional tools for local governments to regulate this activity. And locals go first for cultivation. So if you have cultivation applicants, if you have an ordinance that allows cultivation in your county, they must first obtain a local license or permit before going to the state for a license. Status of C4, this is a phone one. So as most people know, in AB 243, there's a provision that has a deadline. It says if the city or county doesn't have land use regulations prohibiting the cultivation or deals with it under permissive zoning, which is basically not doing anything in your county or choosing not to do anything through your land use controls, then commencing March 1st, if you haven't done either of those two things, the state can come in and be the sole licensing authority. When this was drafted, the last day of session, unfortunately the March 1st, 2016 date was put in there when it wasn't supposed to be in there. And as some member Wood, the author of 243, has committed to taking this out in urgency legislation in 2016. Of course, that comes with all of the problems and barriers we could have getting a piece of legislation done by March 1st, which only gives them 2 months to get that through. So we were trying to alert counties about this March 1st date to be sure that they might want to look at their ordinances and see if they need to do anything or just have that March 1st date in mind in case the legislation does not address it. Let's see. Mobile deliveries. Unfortunately, this is one thing that we weren't super pleased with in the bills. The default in the bills is that mobile deliveries are allowed. So unless your ordinance specifically prohibits mobile deliveries, they can be done in your county. Also, a mobile delivery must originate from a licensed dispensary, which was important to us to allow some controls. But this was primarily those people that were advocating for the mobile deliveries and the Ease folks or the Uber for Pot people really felt that this was important to have mobile deliveries, and so we kind of lost on this one. But if you do want to prohibit them, you have to change your ordinance. Cities have the option to enforce state standards, slide 20. So the cities really advocated hard to have the ability to enforce the standards. So if they ask the state for this authority, they can be delegated this authority by the state, and that's specifically outlined in the bill, AB 266. We don't have an explicit authority because this wasn't something that was as important to us as the cities, and I'll get to why in a minute. There's a local role in enforcement, of course. There's significant provisions in all bills about the locals can have enforcement roles along with the state. We can examine the books, so we can establish standards and regulations regarding health and safety testing, security, etc. Of course, as Karen mentioned, state provides the minimum, but this provides for a coordinated enforcement amongst the state and local governments. Also, there's very strict protocols regarding who can obtain a license from the state. So prospective licensees must get a background check done by Department of Justice. There are also additional provisions regarding who can get a license. So if you have a serious felony or a violent felony, you cannot get a state license. This was also hard fought towards the end, where there were some advocates who wanted to change these provisions. But this is very important to the police chiefs and the public safety community. I think that's you, Paul.
Good afternoon. Paul Smith with RCRC. I'll pick up where Jolena and Karen left off on slide 24. The package, as you see from AB 266-19330, does explicitly allow for employers to have restrictions on medical marijuana use, not just in the workplace, but beyond the workplace by your employees. This was a very another hard-fought provision that we all advocated for. And the main reason is we wanted to make sure that counties could have that tool in case they feel pressure to comply with the Federal Drug-Free Workplace Act, which of course puts potential restrictions on those that do not conform with the Federal Drug-Free Work Act in obtaining various grants and monies and whatnot. And since counties rely on a great deal of federal funding, we wanted to make sure we had this tool so as an employer we could properly comply. Transportation standards are another aspect of the package. Few things here of note. One, all transporters must be licensed, bonded, and insured. There is a special category in the licensing scheme strictly for transporters. They must all have a manifest of what they are carrying at all times and available for inspection. Unfortunately, the legislature in the last hours did not put forth detailed standards as to what would be required of transporters and those that hold that transporter license. Those will be developed at a later date. Some of the things that will likely be contemplated will be things like mandatory 2 persons on a vehicle, times of delivery being restricted to only a certain hours of the day, whether or not they are armored, if they are carrying a certain amount of product or cash or whatnot. So these are all very important things. Also, local governments cannot impede the movement of medical marijuana by licensed transporters as long as they remain on the public roads. This is a really important issue. A lot of folks are concerned between what is a transporter and what is a mobile delivery. A transporter is very, very well defined into the statutes. Transporters and those that hold transporter licenses are moving product from licensee to licensee. And so local governments will not be able to impede that, again, as long as they stay on the roads and they are obviously fulfilling the mission of their license, which is to move medical marijuana between licensees. A mobile delivery is not that. A mobile delivery does not move from licensee to licensee. It moves from licensee to end user, and the rules pertaining that are much different. Some other aspects of the legislative package, there are some appellation standards and organic standards that will be put forth, namely by the Department of Food and Agriculture. Those will come at a later date. The statute also specifically defines cannabis as an agricultural product. I know that has enormous ramifications that are still being contemplated as we speak by folks, but nevertheless it is very clear that the legislature intends cannabis to be treated as an ag product. Pesticide standards were also spoke to in the package, but the legislature failed to provide a lot of detail on this. Instead, they are leaving it up to the regulatory bodies, namely Department of Pesticide Regulation and CDFA, Department of Food and Agriculture, to develop those. Not sure exactly the timing of those, but nevertheless, the legislature has instructed that course of action. Cross-ownership restrictions. These were very controversial aspects of the package. What they do is they try to prevent vertical integration. Those holding licenses in all categories of licensure. There are explicit and extensive restrictions on who can hold a license when and where throughout all of those license categories. The interesting thing here is with prohibitions come some exceptions, and there are a few specific exceptions written into the statute. We anticipate maybe some questions in the webinar as to what those are, but in the sake of timing, I'll just go and let you know that they exist, and be happy to chat further for those that want to get a better understanding of what they are. Finally, this scheme is a mandatory distribution scheme, meaning marijuana product coming off of the cultivation site has to move through a mandatory distributor. A distributor can interchange with the transporter, but it has to be a separate licensee from the cultivator. So that product will move again through a distribution chain of a different licensing segments. The main reason for putting a mandatory distribution is, in addition to minimizing vertical integration, if we see cultivation taxes or something to that effect, having a mandatory distribution scheme makes it much easier for the collection of taxes than otherwise dealing with thousands of cultivators and hundreds of retailers. There are anticipated only a handful of distributors and transporters throughout the state. The legislation is by no means not the only arena to where new rules and regulations are being put forth. Both the North Coast Regional Water Quality Control Board and the Central Valley Regional Water Quality Control Board have issued a set of regulations. My understanding is these have now been fully adopted in both regions. We definitely know the North Coast, and my understanding is Central Valley occurred late last month as well. These are the key elements on slide 29. The most important is the one at the top, that in order to obtain documents from those Regional Water Quality Control Board agencies to cultivate marijuana and there have some type of water discharge and have a waiver for that discharge, you need to adhere to the county ordinances. So one would not be able to get a wastewater discharge waiver in a county that had severe restrictions or banned cultivation. The state will just simply not act on that. Here are some of the other key elements beyond the deferral to county ordinances that are pointed out as well. There were a few things that were not addressed in the legislative package. And so we say the saga continues. Make it very clear that the next few slides here talk about two bills that were not enacted. And I repeat, not enacted. AB 1548 is the first one. This would impose a cultivation tax. I will say that these provisions or similar provisions were in the package at one time, but they fell out on the last night of session. Hence, we have a separate bill by Assemblyman Wood from the North Coast. And as you can see, he's putting forth a variety of taxes at the cultivation level, collected at the distributor level, but administered by the Board of Equalization. One of the reasons for spotlighting this is, Karen mentioned, we do have some provisions that address the environmental impacts, and there is a revenue stream to fund some of that activity. But quite frankly, those revenue streams are inadequate. Hence, a cultivation tax could potentially raise more money for those environmental concerns. And as you'll see that Mr. Wood has written his bill whereby the proceeds would be used for environmental impacts at the state level. The second thing that was missing in the regulatory package that we would have liked to have seen addresses the issue of state banking. Federal law makes it very difficult for any federal chartered or really any institution for that matter to handle monies derived from marijuana activities. Those banking laws obviously need to be addressed, but in that spirit, we still believe that we need to somehow create a framework so that the monies derived within the medical marijuana industry can be properly banked. So Mr. Wood is putting forth what we call a spot bill, which is a bill that's still not to be fully written, but clearly he wants to stake his claim in the ground that we need to create some type of state financial institution to handle banking services. This is important to counties because as we get into the license fees that you would be collecting, as well as property tax payments, we simply don't want them in cash. They are more difficult to audit and track, and compliance just becomes more difficult when you deal with in cash. So obviously we're looking at a strong financial system to help with that effort. Finally, much talk about ballot measures as it relates to this medical marijuana package. There are about a dozen or so ballot measures that have been filed with the Secretary of State awaiting Attorney General title and summary that would, for lack of a better term, sanction the adult use or the recreational use of marijuana. This would go beyond the existing statutes, would speak to only medicinal use. Quite frankly, most of those ballot measures are not envisioned to get across the goal line, so to speak. All but one, and that's commonly known as the Parker Initiative, will likely fail simply because it won't be able to get the signatures in time. However, the Parker Initiative, which was filed 2 weeks ago, does have significant financial backing, both to get the signatures as well as to run a campaign for the November election. All of our organizations anticipate that measure qualifying, and we probably can debate whether it will pass. But it should be noted that the Parker Initiative has much of the language that's in this three-bill package associated with it, including provisions of local control. There are a lot of concerns with it as it stands. In the interest of time, we won't go through them all, but do note that the three organizations are in concert with our concerns with the drafters, as well as others who will be looking at this very closely, knowing that we have a medical marijuana regulatory structure, and we need to adhere to as much of that as possible. So to wrap up, before we open it up for questions, the key takeaways I believe we would recommend to all of our members is if a county has adopted an ordinance on medical marijuana, including a ban, this still will be protected under the legislation. Again, Karen talked about those 4 key local control provisions. They were written for exactly this practice, is that we have won some hard-fought battles in the courts and elsewhere, and we wanted to preserve them. We believe the legislation does that. If a county has not prohibited mobile deliveries, particularly through ordinance, you may want to consider updating yours or enacting one. This is not necessarily a requirement that you do so. That's obviously a decision before your boards. But nevertheless, if a county wants to do that, then we encourage you to consider this sooner rather than later. There is no penalty for early action. But prohibiting mobile deliveries must occur by ordinance, and you would have to go through that process. Within the establishment of a state licensing and local approval scheme, counties that do not ban will need to commence the establishment of a local approval framework. And what this means is that while there is a dual licensing scheme, it's not necessarily clear that a local has to issue a license per se. There are other forms of local approval. And so we encourage counties to start thinking about what they would do under those situations. Again, this is if you do not have a ban, the statutes will contemplate some type of a local approval, and we encourage counties to start contemplating how to meet that. Finally, if C4 is not addressed, meaning the whole section is not repealed or the date is not repealed, then counties will need to pass, we believe, need to pass some type of ordinance on cultivation just to make sure they have, they preserve their options. Again, these are primarily for counties that do not have anything on the books. And we know they do exist. There are probably at least 1 or 2 handfuls of those counties. We encourage you not to rely on C4 being eliminated simply because the legislature does strange and mysterious things from time to time. So again, we ask that you be familiar with C4, but I would argue that it's not necessarily the end of the world if the legislature does not repeal this by the March 1 date, or even at a later date. There are some other aspects within the package that would alleviate concerns with the C4 thing. But in a perfect world, it would be best for this to disappear. So with that, we will open it up for questions.
We do have several questions from the listeners. One question is there any issue with amending an ordinance after March 2016?
Are there any issues? Can you repeat that question one more time for us, Jeff?
Is there any issue with amending an ordinance after March 2016?
There's a few presumptions there. This is Paul, and at this time I'll defer to Arthur after my comments, County Counsel in Tehama. But the short answer, I believe, is no. There are no issues. There are no restrictions upon local governments amending any of their ordinances, whether they be on the cultivation side, the dispensary side, or what have you, after March 1, 2016. If we're speaking strictly on the C4 clause, again, there's no prohibition from doing that. The question becomes, if you act past the March 1 date, do you lose sole licensing authority, or do you defer sole licensing authority to the state for cultivation licenses? That still remains to be seen if that in fact would be the case. But as it relates to the general question, no, I don't believe there's any negative consequences prohibiting you from adopting or amending ordinances past that date.
Hi, am I live? This is Arthur Wylene, County Counsel for Tehama County. I would concur with what Paul said and use this as an opportunity to point out two other, I think probably fairly closely related per 243, and one is section 11362.777B3, which basically provides that a person or entity cannot submit an application for a state license if their cultivation activity will violate local ordinance, and subdivision C1, which is right underneath that, which provides that when talking about a city or county's ability to basically administer the AB 243 conditional licensing scheme for marijuana, specifically says that ability is granted in this legislation or contemplated, does not limit any other current or future local land use regulation. And the reason this is important and that it speaks to this particular question are one of the bigger questions in subdivision C4 is, what happens after March 1, 2016? What happens if the State Department of Food and Agriculture does become the sole licensing authority? Does that mean that we lose all control? And I think with regard to subdivision, B3 out there, which provides that the state cannot issue a license for cultivation, or you can't ask for a license for cultivation in violation of local ordinance. I would certainly argue that there is some local control that will be left, and I believe a fairly substantial measure. And the reference to current or future land use regulations in subdivision C1 still bears that out. So that's a long way of answering the question. Is there an issue with amending an ordinance after March 1, 2016? And I'm going to presume for purposes of the question that you have an ordinance now and that you want to amend after that. I think the answer is no. There is no issue with that.
There are a number of questions about the March 2016 deadline. So I'm just going to say all of them and you can address them in turn. Does it only apply to cultivation ordinance and regulations, or do local entities have to establish all relevant ordinances for cultivation plus every step in the supply chain before that date? Also, one county has an interim urgency ordinance banning new collectives or cooperatives temporarily. Would this interim urgency ordinance qualify as a ban for the purposes of the March 2016 date?
This is Paul on the on the questions. Jeff, can you read the first question one more time so I can be really precise in my answer? Because I think I know what it is, but I'd like to hear it one more time.
Sure, just to go over the deadline in more detail, does it apply to cultivation ordinances regulations only, or must local entities establish all relevant ordinances for cultivation plus every step in the supply chain before then?
Again, C4 is a very difficult provision. It's poorly drafted. I think even the author would admit that. So no issues with me saying that. So again, because of the lack of clarity and understanding of exactly what's going on here, it's not always clear. But I would say in direct response, it's our read of the bill that this applies primarily to the cultivation side. It's written in the sections. I believe it's 11365.777, which strictly deals with a lot of the cultivation issues. So I don't believe this would apply to dispensaries, manufacturing facilities, those types of things. The second question?
Does an interim ordinance qualify as a ban for the purpose?
I know a number of counties are contemplating that, and our read of it is yes, that would satisfy the conditions of C4 as long as obviously it's in place before March. Again, no one really understands if C4 remains what the long-term ramifications are, but clearly I believe it's our belief that that would stand. Again, I will defer to Arthur. I know he's already eloquently talked about some of this ramifications of it, but I defer to Arthur either to contradict me or concur or offer his opinion on it as well. But those are from the lobbyist standpoint and what we understand the legislature's intent during the debates and the discussions is that would be as I outlined in my comments.
I do agree with Paul. With regard to the first question, I believe that the March 1, 2016 deadline does apply solely to cultivation ordinances. It actually talks about cultivation within C4, and as Paul noted, is in the statute that it deals strictly with the cultivation scheme. So about that, I concur. I feel fairly confident. I also concur with regard to Paul with the interim urgency ordinance. I would give two caveats to that, though. One would be that your interim urgency ordinance obviously would need to address cultivation. And the reason I say that is I believe the question was framed in terms of, essentially, sort of a dispensary ban. Not all dispensary ban ordinances talk about cultivation. In fact, some of them are kind of phrased in broad and sometimes somewhat general terms. Definitely, if you're trying to have an ordinance in place prior to March 1, 2016, whether it is a regular ordinance for which you do second reading sometime in January, so it goes into effect before March, or whether it is an urgency ordinance, you definitely want to address cultivation very, very specifically. The second piece was, and this is kind of one of the bedeviling things with regard to C4, and it's just kind of a bit of a drafting issue, is that C4 actually has two different clauses. If a city or county does not have land use regulations that regulating or prohibiting marijuana, or chooses not to administer a conditional permit program pursuant to this section, then the division shall become the sole licensing authority. This has led to a lot of questions with some of my colleagues about, okay, what kind of ordinance do you have to have in order to, have the state not be able to issue marijuana licenses in your county? So, there's some ambiguity in C4 with regard to that. But to more directly answer the question, whether your ordinance is an urgency ordinance or not, I do not believe is what controls. It's really the content of the ordinance that's important, and the fact that it actually be in effect prior to March 1.
And so, Arthur, to follow up on that, and I think you have already addressed this, but just to be clear for the person who asked another question, if there's a current local land use ordinance in place that was previously adopted, does that ordinance remain intact and enforceable?
I believe the answer to that is yes, with regard to subdivision, specifically because of subdivision B2. And so, for instance, I'll put this in terms of our county. We don't have a conditional permit program under 243. Obviously, what we have is an ordinance that regulates marijuana cultivation in terms of number of plants, requiring indoor grows, things of that nature. I do believe that even once March 1st, 2016 passes, once March 1st, 2016 passes, I do believe that because of subdivision, B3, the state licensing, the state folks at CDFA, whether they consider themselves to be the sole licensing authority or not, will not be able to issue licenses in Tehama County for cultivation that violates Tehama County's rules, that has too many plants in an inappropriate location or is an outdoor grow when we say you can't have outdoor grows. Like I said, that's not saying I would encourage people to not have ordinances or to not have strong ordinances based on that, but I do think that whether or not we are issuing permits under CDFA's scheme, I do believe that we can continue to require compliance with the existing local ordinances that we have.
One more question on this part of the presentation, and then we'll move on to a different aspect. But one county has a code that states that any use that violates state or federal law is prohibited in all zoning districts. Is this sufficient to ban cultivation and mobile delivery, or does it need to be explicitly prohibited?
I'll give you the gut level answer. Prohibit. I would not rely just on that. I think it's probably much better, clearer, and safer when you're trying to write ordinances that interact with specific piece of state law, like you have here, to specifically address what you're talking about. I think that I would not recommend trying to rely just on a general ordinance like that. Again, I'm a very conservative attorney, particularly in this area, having litigated several cases. I'm not saying that it's irrational to do so. That would not be my suggestion.
Two questions on CEQA. One, will CEQA provisions apply to cultivation permits? And second of all, will an EIR be required prior to this going forward?
I think we're going to have to defer to Arthur on that one.
And I will say that's you've hit one of the bigger unknowns. I will say to a certain extent that is going to depend on the terms of your local permit ordinance. Obviously, CEQA applies to discretionary actions by local agencies. If you construct a permit scheme for marijuana under AB 233 or otherwise that is discretionary, that is essentially like a conditional use permit, you're probably going to get a fairly decent argument that CEQA does apply. Whereas if you construct it as essentially a ministerial permit, okay, here's your checklist. If you meet the checklist, here's your permit. If you don't meet the checklist, you don't get a permit. CEQA probably won't. With regard to if CEQA does apply, are you going to have to do an EIR? That's really going to have to be determined on a case-by-case basis, depending on, is there, a fair argument that there's a potentially significant impact on the environment. And of course, that's difficult enough to gauge in even more obvious cases than this one. That's something that would have to be kind of looked at on a case-by-case basis, depending on, the specifics of what it is someone wants to do and how much they want to grow and where.
I have a couple questions about the agricultural product designation. One person who asked a question said, please talk more about the agricultural product definition and the implications to things like right to farm ordinances, Williamson Act, etc.
This is Paul. I can handle a couple of those. Yes, the statute is pretty vague beyond saying that marijuana or cannabis is a agricultural product. It's basically that's about it. Yes, that brings in a whole host of things as it relates to that, i.e. Williamson Act being one of them, certified farmers market availability, et cetera, et cetera, et cetera. On the right to farm, I probably would have to punt to Arthur or to see what his experience is on that, and I have a feeling that's going to vary depending on each county and how they've constructed their right to farm. But as it relates to Williamson Act, yes, that's definitely been contemplated. I see no reason why it potentially cannot be part of a Williamson Act contract. But again, I would argue, again, that's a contract that Board of Supervisors would be entering into. So there still is a fair amount of discretion that a board would have if they wanted to go ahead and bring those properties into that arena. My sense is given the fact that we still struggle to be compensated at the state level for those subventions, that boards are not going to be too super thrilled about doing that. But again, that's a local decision. With right to farm, again, those ordinances vary, and again, I'll defer to Arthur on that one if he has comments.
Sure, a couple of comments on this. The first off, I think the language most people are thinking of when they talk about the agricultural product language, it's actually found, it's in subdivision A of 11362.777. The phrasing of it's interesting. It says, for purposes of this section, which is AB 243, and chapter 3.5 of the Business and Professions Code, which is the basically AB 266 and 643, medical cannabis is an agricultural product. And one could argue from there that that is not an all-purpose definition of marijuana as an agricultural product, but is perhaps more limited to those two areas. That said, even without getting into that, that's just kind of a little linguistic piece. Without getting into that, with regard to the right to farm, most right to farm ordinances and the provisions of the Food and Agriculture Code upon which they're based say something to the effect of a commercial agricultural use, and most of them focus on commercial. Commercial agricultural use that has been in place for 3 years shall not, by virtue of shall not, thereafter basically be deemed a public nuisance simply because other land uses move in around them. It's designed to protect uses like dairies, for instance, from having residential subdivisions open up next door and say, hey, the smell is bad, you're a public nuisance, you need to go away. Obviously, we don't have too many marijuana operators right now who would claim to be in business for a commercial business for 3 years, because obviously that's not been the legal model that the industry has been operating on for a while. More than that, we've reasonably successfully argued in a lot of the marijuana cases that I've litigated that the right to farm, the right to farm provisions and related provisions of the Civil Code, those have impact potentially on public nuisance lawsuits and private nuisance lawsuits brought by neighbors. They really are not a limitation on the county's authority to regulate through other ordinances. So I'm not, perhaps I'm being a little bit overly blasé, but that does not concern me that much. I don't think that reading this language together with the right to farm ordinance and statute, unless you get something very strange in your ordinance, is going to result in a loss of local control over these uses kind of indirectly there. I think that's less likely. With regard to Williamson Act, I tend to agree with Paul. I don't think that marijuana is going to be categorically excluded. That said, Williamson Act contracts are contracts. I believe the board will still retain a fair amount of control as to whether that's a contract it wants to enter into.
So with all of this uncertainty around this agricultural product definition, do you expect the legislature to clarify this?
We are all kind of shaking our heads here. No, this is not one that we've heard a lot of chatter about in terms of cleanup and further legislation. That's not to say it won't occur, but we've been in contact with a lot of groups and a lot of offices that are part of this, and that has not come up. I think there's a lot of wait and see as it relates to that.
Okay, a couple questions now related to food. Have foods with marijuana been exempted from the definition of a food and not subject to the California Code that would prevent environmental health food inspectors and expose citizens to foodborne illness?
Well, I'll try. I think there's a code section that talks about the edibles, and that those include chewing gum, and that the medical cannabis edible products are not considered a food or a drug. I think this has to do with during the negotiations on the bills that Department of Public Health was a little hesitant to get, and they didn't know how they would regulate these products or if they were considered a drug. And so I think it's an open question as to how that's going to affect. I don't think it would affect environmental health or their ability to go in, but I think I would defer to Arthur to see if he has any ideas as to whether that would limit our ability to inspect.
I know this is one area that went back and forth a lot during the drafting process. I do believe, and I am expecting, the whole lot of policy issues were deferred to the rulemaking and regulatory phase. I do expect that specific standards for edible cannabis products are one of those things we will see probably fairly specific regulations on, and in turn the state enforcement structure there. No, I don't read the bill to, if somebody is selling, a brownie for sale that happens to have marijuana in it, I'm not reading anything in the bill right now that would prevent our environmental health folks from, whether the brownie contains marijuana or not, from ensuring that it doesn't contain salmonella. And I certainly would not encourage our folks to, to not do that part of their job just as a public health matter.
A couple questions about mobile delivery. With regard to mobile deliveries, BMP Code Section 19340, AB 266, requires the delivering employees to carry and present their, quote, government-issued identification. Is that just a driver's license, or is there a separate identification card issued under the new statutes for MMJ employees?
I think that remains to be determined. This did not get a lot of chatter during the conversation about putting the package together. My sense is we will have that as part of the regulatory package for transporters and or deliverers, probably more on the mobile delivery side. I think it would be very wise that a driver's license be part of that no matter what. But nevertheless, there should probably be some originating documents from the dispensary as it being licensed to make that mobile delivery occur. That's something I think we'll be talking to the regulators about, and my understanding that will be at the Bureau of Medical Marijuana Regulation, which will be handing out primarily the dispensary licenses.
And so if a county already has a cultivation ordinance, but it doesn't address delivery, do they have to update it to address delivery before March 1st?
The March 1st deadline doesn't really apply on mobile deliveries. C4 and the March 1st deadline is, as we've discussed, is predominantly cultivation. All I can say is the statute is very clear that if you want to prohibit mobile deliveries, you need to do that by ordinance. There's no time frame for or against, early, late. That really is a decision before each board. And I'm aware that counties are already starting to adopt ordinances to do that, or amending their existing ordinances to do that.
Yeah, and I concur with Paul on that. The March 1st deadline, whatever it means, doesn't mean that. That's not the deadline for adopting delivery ordinances. That said, you do need to have one if you want to prohibit deliveries in your jurisdiction. Sooner is always better than later. So, I wouldn't let the lack of a deadline there, induce you to not take action. Do it as if you're going to do it as quickly as you can.
We have another question on this. This C4 seems to be an explosive issue. If county bans all cultivation, would they disqualify themselves for any possible grant funding to deal with environmental degradation caused by illegal cultivation?
The short answer is no, and we were very, very astutely aware of that situation when we crafted the package, or at least helped influence the package. No, the grant fundings that would be available are for all marijuana activity, not just licensed marijuana activity or activity occurring only in licensed jurisdictions. It is to protect the integrity of the entire licensing scheme, so nothing would preclude those from applying from those grants.
Back to edibles for a moment. Is it expected that CDPH will delegate the oversight of marijuana edibles to the local health departments?
Not necessarily. Legislation doesn't say that. I think it's wise to be concerned about that and to follow the regulations closely, because they certainly did want to have that in earlier versions of the bills and in previous legislative sessions. But we were very adamant that that not be a mandate on the county health officers. But we certainly need to watch the regulations closely to ensure that they don't mandate or have a role for the county health officers.
One additional note on that, I would encourage folks who are interested in that particular issue to take a look at 19316B, which is part of AB 266. Basically, there's a sentence in there that essentially says that if a city basically permits a licensee within city limits, the city will assume complete responsibility for any regulatory function relating to those licensees within city limits that would otherwise be performed by the county or any county officer or employee, including a county health officer, without liability, cost, or expense to the county. And that was designed to address the situation in which a county, maybe bans licensees, isn't really interested in having anything to do with them. A city within the county wants to have a dispensary. That dispensary wants to sell edibles, but the county is still not really that excited about having its health officer or its sealer of weights and measures regulate that facility. That was designed essentially to shift that burden, whatever burden that happens to be, which I agree is remains to be seen, but to shift that burden to the city officials. And I think 19316B pretty effectively does that.
We have time for just a couple more questions. If a county already has a cultivation ordinance that allows only indoor permitted structures growing, then that county still has to establish a local licensing structure, correct?
Not
Potentially.
necessarily.
I'm sorry. Do you want to take it, or do you want me?
Paul, you go first, and then I'll respond.
The answer is not necessarily. Again, as we spoke, the statute was not written with instructive requirements as to what deems a local. It's contemplated, and I think most would assume it's a local licensing process, but not necessarily. It doesn't require a local license. It requires some type of local approval, either a license, a permit, or another term that conforms to the land use practice of that jurisdiction. So this is where I will defer to Arthur to get into the more specific options, but the short answer is not necessarily. It really depends on the overall approach that that jurisdiction wants to utilize. But Arthur, I'll let you expand upon that.
Certainly, and this kind of comes back to it depends. Part of this depends on what you want. What do you want to do as a county, as Paul indicated? If you as a county are interested in having commercial licensees, you actually would like to have a commercial cannabis cultivation licensee in your business. It's good for economic development or whatever. Then yes, if that's your policy approach, you're going to need to have a licensing scheme or a permit scheme that is going to interface with the state's AB 266, SB 643 scheme. If your simple desire is to just keep doing what you're doing now, having whatever cultivation that exists in your county comply with your indoor grow requirement, and basically be as little bothered by the state as possible, then that opens up, I think, two of the questions that we had talked about earlier. One, what do you need to do? What kind of ordinance do you need to have in order to avoid, quote, the state being the sole licensing authority? Does it need to be a conditional permit scheme, or is simply a regulatory scheme that just says, here's where you can do it, here's how you can do it, here's where you can't? And two, if the state does become the sole licensing authority, what is the effect of that? If they're a sole licensing authority, but they can't issue a license that's in violation of your indoor grow requirement, is that a bad thing? Like I had said earlier, maybe this is a little bit foolhardy, but I think it's reasonably safe. Tehama County's ordinance that we have is exactly like that. We have to grow indoors in an accessory structure, with a variety of other limits. We do not have a conditional permit scheme. We certainly intend to take the position that, one, that meets the first prong of Section C4. It is a land use regulation regulating or prohibiting the cultivation of marijuana, and that, two, even if that isn't, and even if the CDFA did become, quote, the sole licensing authority, they better not try to issue any licenses in Tehama County in violation for cultivation that violates our ordinances in light of subdivision B3. So is that the only way to do it? It isn't. There may be more conservative ways out there, but I think that's a reasonably decent approach.
Is there a deadline for the passage of taxing ordinances?
Short answer is no. There is no deadline. This is a tool that is available to you as long as the statutes remain on the books. and the Constitution is in place with respect to counties and their taxing powers. I will, though, parenthetically say a reminder that I think this was covered by Karen or maybe Jolena, that to adopt these taxes, you still have to go through the traditional tax approval process at the local level. So you are going to require a vote of the people, and depending on what you do with the proceeds, it may be a 2/3 vote, it may be a majority vote. So that in of itself creates its own deadline, if you will. But as a matter of the statute, no, there is no deadlines for considering or enacting local taxes.
We're going a couple minutes over here just to get to 2 more questions. If your personal use requirement is under 100 square feet and caregive use is under 500 square feet, is a local approval framework necessary?
The short answer is yes, provided that Section G, which is that 11365.777G, the last sentence of that remains, and that is the line that gives locals the ability to enact rules and regulations for personal grows and patient caregiver grows. Those are the 2 entities that are exempt from state licensure. I think Jolena hinted, and I think it's very wise to be aware that that Section G will most likely face much discussion when the legislature returns. Assuming the legislature does remove us, then remove that clause, then there is some ambiguity as to where that will leave jurisdictions. One could argue that the local control provisions already give us some powers. Others might argue that they would not. But yes, as you see in the entirety of Section G, there is a 100/500 square foot threshold for when certain activities can occur both at the state level and perhaps even at the local level. Arthur, I don't know if you want to opine any more on that.
Just really quickly, I think the way I'd understood the question was, do you need to have a local licensing scheme or local regulatory scheme? The answer is no. In theory, you could let personal cultivation go unregulated if that's your policy choice. Second, if you do have such a scheme, will those who fall within those limits be required to comply with it? With the current language with subdivision G, the answer is clearly yes. I think if that language were to go away, I think there's still a decent argument that the answer may be yes, because we don't, even without specific protective language, the courts do not find preemption of local ordinance that easily, and they've made that clear here. That said, keeping subdivision G obviously is an important and good thing, and we like it being there.
Then the last question before we wrap up for the afternoon. How much does the medical marijuana statutory scheme jibe with the proposed initiative authorizing recreational marijuana?
This is Paul. Okay. I'm told that I'm shouting a little too much. I've always been known as a loud guy, so I apologize for those that I'm blowing your ear out. The answer is there's a great deal of overlap between the Parker initiative and the statutes we've been talking about. Keep in mind there are a dozen or so other ballot measures that are being proposed out there. So again, I'm only going to speak to what I'm aware of in the Parker initiative. I have not gone through, and I don't think much of us here at the lobbying level have looked at the others for the reasons we talked about. But as it relates to the Parker initiative, yes, same licensing entity, same licensing categories, although the Parker initiative adds a couple more. There is no dual licensing scheme, but there is a strict state licensing scheme associated with it, very much modeled after the regulatory package. There is a great deal of local control provisions. They're pretty good. They're not great, but they're pretty good. Where there are some weaknesses, clearly the local control is not supreme. There are some exceptions and some limitations on that. There's the mobile deliveries is not as favorable to us, although one could argue we still could retain some powers there. The restrictions on ownership of licensing is virtually nil. some inadequacies there. And then right now, the version does not have the explicit county taxing authority language that we'd like to see there. But as a regulatory structure, it is very, very parallel. Not identical, but when you look at the others proposed and the others being contemplated, you can clearly see that the influence of AB 266, AB 243, SB 643 were in the minds of the Parker Initiative writers.
We'd like to thank everyone for joining us today. Karen, Jolena, and Paul spent a lot of time together this past year working on these bills, and no doubt they will continue to work together a lot in the coming years to deal with some of the issues they discussed today.
We're planning on going on a cruise during the holidays together, all of us, so we're really going to do some more bonding.
The Emerald Triangle.
Yeah, we're going to cruise the Emerald Triangle.
I'd like to remind everybody on the call that a recorded version of the webinar will be uploaded within 48 hours. That'll be available on our organization's websites. The PowerPoint presentation is already available on all three websites, either under Hot Topics or under the medical marijuana issue area. We'd like to invite you to join us next month on December 16th for a webinar about what to do, what local officials can do during an emergency, whether it's fires, floods, or earthquakes. We'll be joined by Mark Pazin with Cal OES and the emergency manager from San Joaquin County. Until then, thank you very much for joining us.